All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in case number CV230485 in the matter of the guardianship of AK, a minor, and real party in interest. The third member of our panel, rather the presiding judge of our panel, Judge McMurdy, is indisposed today. He is watching these proceedings, but he is not going to join us in person. However, he is still deliberating with us, and he has submitted some questions which we will ask of you on his behalf. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellants, counsel, and real party in interest will split your 20 minutes. And so you're responsible for watching the clock if you'd like to reserve any time for rebuttal. Also, we have read the briefs and discussed this case in conference. And with that, you may proceed.
Good morning. May it please the court. I'm Tom Jost, and I represent Jake and Daisy Danforth. Also at appellant's table is Denise Carroll, who represents real party in interest, the child. The question that confronts us today is whether the Superior Court prejudicially erred in dismissing this case, this probate case. It did for at least 3 reasons, each of which is independently reversible. So first, it errantly held that it lacked jurisdiction. Second, it failed to give several of the parties due process of law before dismissing the case. And third, even assuming that ICWA applies and that the tribe had concurrent jurisdiction, the Superior Court reversibly erred in failing to follow Juvenile Rule 322 in transferring the case to the tribe. So first, even if ICWA does apply, the tribe lacked exclusive jurisdiction. So where did the Superior Court go wrong? Well, it went wrong in looking at a case, an out-of-jurisdiction case with different facts rather than starting with the text of the statute. So if we start with the text of the statute, the first sentence of 1911A in ICWA tells us that tribes will have original exclusive jurisdiction only when the tribe is residing or domiciled on its reservation. Here it is clear that the child was not, so the tribe cannot get exclusive jurisdiction under the first sentence of 1911A. Instead, the tribe now argues that it retained jurisdiction under the second sentence of 1911A, and there are a few problems with this. So the second sentence does not allow for original jurisdiction, but rather retaining jurisdiction that was already granted. And so the tribe is arguing that it had jurisdiction over the original severance. And it does this by looking at several of its tribal provisions, saying that it has personal jurisdiction no matter where the child is residing, and that it has subject matter jurisdiction regardless of a parent's fitness. So there are problems with each of these. First is there's a geographical problem with its idea of personal jurisdiction, and that it's preempted by ICWA itself. So ICWA states when there's a division between tribal and state sovereignty, how jurisdiction is meted up. And it specifically says that a tribe will only have exclusive jurisdiction when the child is residing on or domiciled on the reservation. So as far as any tribal code giving the tribe jurisdiction beyond that, it will be preempted by ICWA itself.
So suppose that we are with you on that argument and there isn't exclusive jurisdiction. What happens? What's the end of our decision say, and what is the Superior Court to do with that?
Well, this would be a remand for an evidentiary hearing. So if ICWA applies and this court is inclined to say that the tribe lacks exclusive jurisdiction, but that there might still be a concurrent jurisdiction issue, then it has to be remanded for an evidentiary hearing and compliance with Juvenile Rule 322. And that was one of the biggest problems that we had here at least as far as the child's rights go, is that under Rule 322, any other party has the ability to object and give good cause why the case should not be transferred. Obviously here, the child wasn't present, wasn't represented by counsel, and didn't even have her GAL there. She was completely denied any opportunity to object to a transfer. So even assuming that there is a concurrent jurisdiction issue for the Superior Court to look at, the child needs to be involved in that, at least through an attorney or a GAL, even if not personally. And then the subject matter jurisdiction that the tribe claims it had after entering in the adoption has a due process of the laws clause problem under the 14th Amendment. So as we argued before, parents have a fundamental right to the care and control of their children, and here we see that the adoption itself says that it gives to Karen, or gave to Karen, the full rights of a biological parent. So in that case, the adoptive parent steps into the shoes of the bio parent and is vested with the rights that we see under Santosky or Troxel v. Granville.
And you say a few times in your supplemental briefing that the tribe, post-adoption, that the tribe was put into the same position with AK as they would have been had the adoptive mother been a fit mother of an enrolled child. And you cited to the Children's Code, and I see that where you cited, I want to know where you get that proposition. Is there someplace other than the Children's Code that tells us that? Because I wasn't completely tracking with the provision that you were citing in the Children's Code as a proposition for that statement, which, if true, is important. So,
well, and it depends which version of the Children's Code we're looking at. So at the time the adoption order was entered, the Children's Code was substantially similar to what Arizona's adoption statute is. They since amended it in 2016 to a customary adoption standard. But at the time, it was still said, and the order still says, that it gives all the rights as though Karen was a biological parent. And how we get to why they couldn't bring in continued jurisdiction after that is it's the same thing that we see in criminal cases, right? You can't do a Terry stop without reasonable suspicion. You can't issue a warrant but for probable cause. In order for the government, and that's tribal or state, to interfere with the rights of a fit parent, there at least has to be some allegation of unfitness. There has to be some reason to get involved there, whether that's reasonable suspicion, probable cause, what have you. Here, after the adoption was entered, there has never been any allegation that Karen was in any way unfit. So to retain jurisdiction over a fit parent and her child violates the due process of the laws clause of the 14th Amendment. And we see that in cases like Troxel and Santosky.
And I don't want to get you too much off your game, but I know we have quite a few questions,
okay.
And I see the time ticking. And so one of the things that I think that we're looking at is the four places where there could be a child custody hearing. And I think both the tribe and appellants focus their arguments on foster care placement and dependency and telling us what things are and aren't. But nobody really talked about the pre-adoptive placement factor. And so why, other than the fact that we don't see the word guardian in pre-adoptive placement, we do see foster care home. And if we're reading what a guardianship is in Arizona, and why doesn't that fit into what a foster care home is, aside from the fact that guardianship isn't mentioned in 3? I understand that. But could what the Danforths are proposing that they do still be considered to be a foster home in the definition that we have in Arizona?
I don't believe so, because what we see in Arizona is a foster placement turns into a guardianship through a Title VIII guardianship process is normally how we see it. So even in Arizona, we consider those to be two different things. After a guardianship is entered, we don't still call them a foster placement, we call them guardians.
But regardless of what we call them, what they are, how they stand with the child and what they're providing for the child and the rights that they have, how is it different?
Well, so we wouldn't really see it different vis-a-vis the rights of the child. I think we see
I'm saying that what the rights and responsibilities that the Danforths would have as to AK seem very similar to me between a guardianship and what we define as a foster home in Arizona. And so if there's such an overlap, why couldn't the Danforth be considered a foster care home? And again, not the statutory interpretation argument, but just a pure definitional argument.
Yeah, just from what it is how that can be rescinded, right? So if you are a foster care placement, DCS can just come in and say, hey, we're pulling the kid out now and we're moving him. We've done some transitional visits with the new placement, but ultimately the decision is up to us statutorily. And sometimes there might be a CPC filed in that for the court to approve it, but not always. However, when you get to a guardian, that's different in the rights of the guardians themselves. So the child's rights don't really change much, but the rights, the due process rights of guardians are different from that of foster parents, and guardians have higher rights than do foster parents. And part of that is because, especially under a Title 14 guardianship, you don't have the state involved. So under foster care, it's the state is also still a party and still has at least something to weigh in on removing that child, disrupting that child from a foster care placement, whereas in a guardianship, they really don't. There are supposed to be the 6-month hearings. What we've been seeing in practice is a lot of even the Title 8 guardianships are dismissed after about a year, and then we just wait to see if somebody wants to revoke that guardianship, which is itself a much different process than when you're talking about disrupting children from a foster care placement, especially when you have an active dependency. So I'd say that's another big difference, is that foster care placements generally in Arizona rely on an active dependency, whereas a guardianship doesn't need that, especially a Title 14 guardianship like this one.
All right, so that would be the answer for why it doesn't fit under a foster care placement definition. Talk to us about the pre-adoptive placement. Why would this not fit under that definition?
So again, the pre-adoptive placement, again, uses that same difference between what is, a guardian and what is a foster care placement. And so we have to look at the congressional intent here and using the terms that it did. And so if we are using a different term for guardian from foster care placement, because they do have actual real world differences, we have to apply that in a way that gives effect to each word that Congress used. So if we're just going to say, hey, we know that guardians and foster care placements are different, but we're still just going to apply pre-adoptive placement to guardians even though it's not said, that's judicially adding in text to the statute that Congress did not use. And again, there's no need to read the text broadly to try and keep an Indian family together, because there was no Indian family here to keep together. So that's in compliance with the SCOTUS case, adoptive couple 570 U.S. 649, that says, hey, when there was no existing family, we don't have to add in terms to try and figure out what Congress would want, because Congress's intent here was to prevent governments from breaking up Indian families, and here that intent isn't.
Can you repeat that site?
Yeah, that's adoptive couple 570 U.S. 649.
Thank you.
So then does ICWA never apply after formal adoption proceedings?
Well, it can. It depends. So you could have a formal adoption proceeding, and through any number of things, the child could come back onto the reservation and be domiciled or residing there, right? You could have an adoption where they have, the adoptive parents have, say, an informal but good relationship with the bio parents, and eventually the kids are spending more and more time back on the reservation with the bio parents, and then something could happen there. So that's going to depend first on residence or domicile, and then we're going to have to look at the other provisions under 1911 to see if it does. But it's certainly not never. It's just that putting the adoption in, especially when it's an adoption like this that gives the adoptive parent the full panoply of parental rights, we're just back at fresh. So then if the facts then after that point change that would implicate ICWA, they do. But in this case, they didn't.
Can you give me like one or two more examples of a post-adoption case where you think ICWA would apply?
Sure. We could look at something
What if there's
where
a dependency of that parent? What if that parent is judged at some point to be unfit? Does a dependency of the adoptive parent allow the tribe to come back in?
Yeah, I mean, even if the child isn't residing on the reservation, I think that would still implicate possibly concurrent jurisdiction, depending on how it goes. So say you have an adoptive parent who ends up being unfit, who's not on the reservation, child gets removed and placed into a foster care placement by state services, that would implicate ICWA and would implicate transfer proceedings. But again, even if that was implicated here, the court erred in failing to make the proper transfer proceedings. So that still here doesn't lead us away from reversible error.
If mother was otherwise fit, as I don't think there's any allegation she wasn't, and her will had been probated and she'd chosen a guardian that the tribe thought went against, the tribe had an interest in saying that this guardian wasn't proper for the child, would ICWA be able to be invoked if that was going through a post-death will probate proceeding? I know I'm going far down the field, but I'm trying to figure out, if you have a legal adoption, what are our limiting principles about when the tribe could and couldn't come back in, given that there are full legal rights to the child elsewhere?
Well, I would say there we should look at case law that has, say, the custodial parent is non-tribal and living off the reservation, and when do those cases apply? Because that's going to factually be a very similar situation to ours. There's going to be a little wrinkle if there still is a surviving tribal parent, but here, if you're looking at the main custodial parent being non-tribal and off the reservation, I think that would be a good starting point to see what other cases we see post-adoption where ICWA might come into play again. So moving back a little bit to the due process issues, is that the Superior Court failed to conduct an evidentiary hearing and then relied on erroneous facts in making its decision to dismiss this case.
Do you have any better authority for the fact that the statute says that you're entitled to a hearing, but doesn't specifically say an evidentiary hearing?
I don't, but I think at a bare minimum, the child didn't receive any hearing.
Well, I mean, and that's arguable, but you've made a point that it should have been an evidentiary hearing, and I'm wondering if you have any more authority for the fact that here you're arguing there really was no hearing. I mean, there wasn't an opportunity for anyone to be heard, so that's not a hearing under any definition. But I was just wondering if there was anything more specific that said that this had to be an evidentiary hearing as opposed to just a hearing where everyone actually got to address the topic at hand.
For an evidentiary hearing specifically, I think the closest we had was in the probate code, but if I remember correctly, that didn't specify an actual evidentiary hearing.
Okay, thank you.
I think that might just be a more matter of judicial solicitude, that's probably on remand going to be the best way to clear up these issues, as we do have still outstanding issues of fact.
Yeah, and I'm not arguing if it was remanded what you should have there. It's just that you make the argument that it's due process violation because you didn't get an evidentiary hearing. But
I mean, really, it's any hearing.
Okay.
And I'll just touch on UCCJEA a little bit and try and save a couple minutes here. So even if ICWA applies, UCCJEA does not apply, and that's under ARS 25-1004, and there's a little nit in that Holly C. said, well, if there's anything above ICWA, the UCCJEA could still apply as long as it gives greater protections, but that court, or this court in that case, did not identify anything in UCCJEA that would survive that. And it's also interesting to note that UCCJEA does not define an adoption as a child custody proceeding to which it would be subject. And I note that because that's consistent with the thought that an adoption is not the same as a custody order or a placement order in a Title VIII case, is that it is a different thing that starts everything afresh. And the UCCJEA seems to recognize that. So if we're looking at if this is an initial child custody determination, well, Arizona is clearly the child's home state, even though she was temporarily in Ohio. So if this is an original determination, that's the end of the analysis. We're done here. Even if it's a modification of an adoption, it still is important that Arizona was the child's home state, and that at the time there was the child, neither her parents nor anybody acting as a parent was residing on the reservation. So under the UCCJEA, Arizona courts could still modify that even if it was a determination.
Can I circle you back? I apologize. Judge McMurray is asking, is there a federal definition of foster home?
I am not aware of one in ICWA, and I have not seen one in the case law that I've read.
Okay, thank you.
So to the best of my awareness, but if this court would like a supplemental citation of authority on that, I can certainly do a deep dive.
Okay.
If there are no more questions at this moment, I'd like to keep the rest.
Sure, all right, thank you. Thank you.
Actually, why don't we have the real party in interest now? and then we'll give you an opportunity. Perfect.
Good morning.
Good morning.
I don't want to use up a lot of Mr. Joseph's time, so I'm going to just cut to the chase. I have 10 pages of stuff just in case I needed to argue, but basically I have really two concerns with this. I represent AK, a little girl that was very traumatized by what happened. And I have been upset about this case from the day that I read it, because this child was ripped from people they knew and moved. And I don't know if she'll ever get over that. But what I am asking this court today is to send this back and remand it, because I do believe that this child had no chance to express her opinion. The guardian ad litem was asked not to be there. It was supposed to be kind of a rubber stamp, wasn't there. And what I cite the court to look at is 25 U.S.C. 1911B, which allows a transfer to a tribe. But there's a really important phrase in that, and that is about the absence of good cause. Well, who would have brought the good cause that day? The guardian ad litem. The guardian ad litem was the only person that could represent that child, and that person was not there. So how could we have a hearing, even if it wasn't an evidentiary hearing, with no one able to protect that child to say, Your Honor, this is good cause. This child has been there since birth. These are the only person this child knows. These Danforth had taken care and were going to be the guardianships of this child at one point, but there was nobody left to talk for her. How unfair is that? This child was traumatized because they didn't even give her guardian ad litem a chance to bring that cause. So that's really all I have to say to this court. And I appreciate that the court understand that this child needs to be heard. And the best way to do that is to remand this case back to the court to allow the guardian ad litem, and if I'm appointed, the attorney or another attorney, to speak for her for what her wishes were and if there's good cause.
Thank you.
Good morning. May it please the court, my name is April Olson and I represent the Gila River Indian community. With me at council table is Sunshine Manuel, who is the senior counsel for the community. She's co-counsel, and I want to point out for the court's information that the governor of the Gila River Indian community and members of council are present in the audience, because this is such an important case to the community.
I'm having just the slightest problem volume-wise. Yeah, I just want to make sure I get every word. Thank you.
All right. This court should affirm the dismissal of the Superior Court in favor of tribal jurisdiction. Now, there are several theories of jurisdiction in this case, and under all those theories, the road leads back to the tribe. And I want to start with addressing what the court asked the parties to address in its last order, and that is whether this court originated in the Gila River Indian community back in 2010 and 2011, or whether it originated in the state court and was transferred back to the community court. This court originated in the Gila River Indian Community Tribal Court. Shortly after this child was born in 2011, the community removed the child from her parents and placed her in foster care. And they did that under their inherent sovereign authority as set forth in the Children's Code. When the mother failed to reunify with the child 3 years later, the community again exercised its sovereign inherent authority that is recognized by federal law and placed this child for adoption with the mother, Karen. And again, exercising its authority, it did that. In 2023, when the community issued the ward order out of concern for the safety of this child, again, the community was exercising.
So are you saying that a legal adoption that transferred all parental rights to another person, that has no effect on the ability of the tribe to claim that it keeps jurisdiction? I mean, is there nothing then? I mean, to me, if the child is adopted and all legal rights are given to someone who's not a member of the community, and the tribe can come back in, then it can always come back in. And it makes me think, is that a case where any enrolled member, for any reason at any time, the tribe continues to have jurisdictional sovereignty over what happens to that child? Because I think it's kind of a slippery slope, and so.
Sure.
And maybe you believe that they do, but I want to know that.
Your Honor, I don't think in every situation the tribe would come back and assert jurisdiction. But the specific facts of this case.
But could they? You said I don't think they would, but I'm asking you whether you're saying legally they could, under your theory that a legal adoption does nothing to break the jurisdiction that you have over that child in that case.
Under inherent sovereign authority in the Gila River Indian Community Code, once the tribal court asserts jurisdiction over a minor, so it's somebody under 18, then under their code, that jurisdiction does not terminate unless the child turns 18 and unless unless the court expressly terminates the jurisdiction. And that is the tribe's right to make its own law and to be ruled by it.
Do you have a site? I'm sorry. Do you have a site for that? And then
For the Gila River Indian Community Code?
Yeah, for the code that says that.
Sure. That site is Children's Code 7.104C. And that's where it says the children's court jurisdiction shall remain in effect until a child reaches 18 or the court enters in order to terminate jurisdiction.
So, counsel, a party submits to a court's jurisdiction when it appears, and in this case, the tribe did appear in the guardianship matter that was initiated in state court. So what support does the community have for its argument that it could still initiate its own case in tribal court after it had already entered an appearance in the state proceedings?
Certainly, Your Honor. So the community in this case only learned of this guardianship petition a day and a half before the July 20th hearing. So at that point in time, the community didn't have all of the facts before it. They were not made aware, for example, that the petitioners had left the state of Arizona. They were not made aware that there were no background checks and no fingerprints done in this case. Put simply, there weren't any facts that the community was aware of at that time that the community knew they could assert a child in need of care petition or a dependency matter.
Could you have asked for a continuance of that hearing to investigate those facts before you appeared?
Well, certainly they could, but the community appeared, and based on the facts that were known, that's why the hearing was continued another week, so that the community could investigate.
But that's not answering my question. If you were saying that you didn't have enough time to investigate the facts, could you have done anything to put off the hearing, either by filing a motion to dismiss and saying, look, we want to just kind of placehold this because we haven't had time? You appeared, which has, as Judge Cruz said, it has meaning to appear as opposed to file a motion to dismiss or say there's a jurisdictional problem without appearing.
The community certainly could have filed a motion to continue, but given that this child didn't have any legal custodian or any guardian, they felt the urgency to appear. So they certainly could have moved to continue. But even if they did appear, under ICWA, under the terms of concurrent jurisdiction, a tribe can appear in the case and then move to transfer the case, and simply by appearing, they don't lose jurisdiction.
But they didn't do that. They didn't move to transfer.
No, not in this case, because they believed that because this child didn't have any legal guardian and over 90 days had passed from the time that this mother died until the community was notified of this case, 90 days had passed, and this child didn't have any services. There was nobody to do a welfare check.
Let me interrupt you for a moment. So we're talking about what's happening in the state court and the fact that the community did enter an appearance and then initiated these proceedings in the community's court. But at the time that the proceedings are initiated in the tribal court, there's no notice given to that court that there are state proceedings in place. Why is that?
Your Honor, are you saying there was no notice given to the tribal court that there were state court proceedings?
Well, when you file a tribal court case, you didn't say that there was a current state court guardianship case, and in fact said that basically there was no one to care for this child, when in fact there had been a guardianship filed by people that the tribe was on notice knew had a relationship with the child, wanted to have guardianship, and none of that was stated to the tribal court. And the question is why?
Your Honor, I'm not sure that it's factually accurate that wasn't that wasn't.
Assume that it was.
Assuming it wasn't provided to the tribal court, I think what was important for the tribal court to know, and what is important in this case, is that there wasn't a legal guardian in this case. In the community's judgment, as a sovereign, and in this case, Tribal Social Services was acting very much like the Department of Child Safety would. In this case, because there was no parent, there was no relative, there was no guardian, a background check had not been done on this family. This child was taken from the state
And if you
of
had said
Arizona.
that the background, that there were guardians that had filed in state court and no background check had been done, that's a different story than just saying the child's in need of services because no one's there. I think that's just the question.
Certainly, and I wasn't at the tribal court proceeding, and so I can't say what was told or informed at that time. But certainly, the tribal court would have taken into consideration, and this is even in the hearing transcript from July 20th and July 27th, the tribal court would have taken into consideration the Danforth as a possible placement for this case.
Right, but the question really is whether the tribal court had the right to have that information when they're trying to make a decision as to this child who is purportedly with no one to care for her.
And the information is in the record, so we've seen it.
And, Your Honor, I would have to go back and look at the record, but I believe what the tribal court was told was that there was nobody who had legal guardianship of this child and her parent had died. The tribal court would likely have been informed that there were placement options for this child, including friends from church. But that doesn't alleviate the concern in this case that there was no legal custodian and that the community as a sovereign has a right to investigate this family and a right to say there's nobody who is legally responsible for this child, nobody who can get medical care, nobody who can make educational decisions, and it's been over 90 days since there was anybody available to do that. And it was the tribe's sovereign right to say, we want to protect our children. And under these circumstances, we feel that we need to file a dependency petition. Just like if the Department of Child Safety had been aware of this case and had been aware, they certainly could have filed a dependency petition as well.
Now, counsel, there's precedent that says that jurisdiction is established at the time of filing, and at the time the Danforths filed their petition, there was no ward order. Doesn't this mean that the community did not have exclusive jurisdiction at the time it issued its order?
Your Honor, no. The community believes that it still could have had exclusive jurisdiction under its inherent authority and under the fact that under the Gila River Indian Community Code, the community retained jurisdiction from the original dependency and adoption proceeding that started back in 2011.
Has your children's code changed since the time of adoption? When you were speaking earlier about what the jurisdictional, that once you have it, you keep it, was that the same as the code stated at the time of adoption?
No, there have been a couple amendments to the code since then. I can't say today that provision is the same as the prior code, but I certainly could file a supplement to the court and include the amended children's code from previous versions.
Okay, thank you.
Is it the community's position that Allie was awarded in 2014 or before?
The community's position that the child was awarded in 2014 and before? Yes.
And is there any record evidence of that?
Yes, Your Honor. So the community did, in compliance with this court order, file a sealed copy of the tribal record. However, because the parent changed from 2010 and 2011 to 2023, the record that you have is the most recent record. There is a complete tribal record from 2011 when the community filed their dependency petition and when they first made the child a ward of the court. And the community would be willing to contact the court and the tribal court and file an amended supplemental record if the court wants to see that. But I can assure you today, as an officer of the court, that this case started in the community court in 2011 when the child was declared a ward, and it never was in the state court.
Can you tell us why the community did not argue that this is a case of a pre-adoptive placement as opposed to a foster care placement?
Sure. And
if I can add a caveat, especially since the foster care placement says that that parental rights have not been terminated, so it's a dual question.
Certainly. And, I think, Your Honor, it's important to acknowledge there are very unique facts in this case that are likely to be replicated. You know, we have a very unique situation here where this was an Indian child adopted by a non-Indian person, and then that non-Indian person passed away. So I want to acknowledge that they're unique circumstances. I do agree with Your Honors that for all practical purposes, this was a pre-adoptive placement, and that should have been something that was addressed more at length in the briefs. I also want to point out that the child custody proceedings under ICWA is not an exclusive category. I know that they name 4 categories, and I do agree with Your Honors that this certainly, for all practical purposes, is a pre-adoptive placement, but it's not exclusive. And in fact, the definition only excludes 2 types of proceedings, and that is delinquency and divorce. So I think child custody proceeding accounts for situations where maybe the exact situation doesn't fit the letter of foster care placement or termination of parental rights. But you're correct that for all practical purposes, this was a pre-adoptive placement. And in addition, it wouldn't make sense to hold that ICWA applies to foster care placements, to Title VIII guardianships, to emergency proceedings, and to adoptions, but that it doesn't apply to a Title XIV guardianship. That's not just consistent with the purpose or the plan of ICWA.
But, and I'm going to ask you, but what about the statutory construction argument that just 2 subsections above we see that guardianships are front and center and listed, and then we have a list that doesn't include them that still includes foster homes. So how can I read around that and find this as a pre-adoptive placement?
Your Honor, again, I think child custody proceedings is not an exclusive list.
Assume that I think it is.
Well, I will point out in both the amicus briefs and in the supplemental brief that we filed, there are numerous courts that have found guardianships to be.
But none of them have found that when it's been, when someone has adopted the child. They've all been in places where there aren't legal rights to another person to be the parent and that parent's fit. And I don't see, and if you do, I would love to have it. If there are any cases that are post-adoption where we have said that if there's a guardianship there, that somehow ICWA applies.
And sure, and maybe I'm misunderstanding your question, Your Honor. Are you referring to the guardianship that the Danforths had? Because
I am.
Okay. So I want to get to that, and I do want to get to the due process.
Because I'm saying guardianship's up here in foster home placement. It's not in a pre-adoptive placement. And the cases that we have that say that you hold on to jurisdiction, that none of them are post-adoption analysis. So if guardian's listed upstairs, but it's not listed downstairs, how can I say this is a guardianship downstairs from a statutory interpretation perspective?
Then I think you say that it's the guardianship upstairs. I think, you know,
but there hasn't been, but there hasn't been, the rights have been terminated. So I, you know, if I'm loath to do that, right, and I'm searching for a place where ICWA applies, and I'm looking in pre-adoptive placement, and I say, well, a foster care home kind of looks like what an Arizona guardianship is. Why can't I just fit it in? I'm knocking up against the fact that guardian was listed upstairs but not downstairs. Make the argument why I can still do that.
Sure. And as pointed out in the amicus and in our supplemental brief, there are courts that have said a foster care placement does include a guardianship.
Not post-adoption.
There's even a court that says termination of parental rights, a death is considered termination of parental rights. So it could fit or include under that category. And another thing I want to point out, Your Honor, it is hard because of the unique facts of this case to just pigeonhole entirely into one category. But the Indian Child Welfare Act doesn't just protect tribes and parents, it protects children. And under the placement preferences section, for example, as an Indian child, this child would be entitled to be placed within the placement preferences. And so simply because the fact that this doesn't fit neatly into one of the 4 categories of the child custody proceedings doesn't mean that ICWA doesn't apply and doesn't mean that this child is not entitled to the protections of ICWA.
If we had, if the mother here had died and there was because these facts aren't before us, but assume there was a will and assume she'd appointed a guardian and assume that probated right away, would the tribe be able to insert itself into that case if they didn't like the guardianship that she'd included in her will?
Your Honor, I think it really depends on the facts or circumstances of the case, but here we are only left the facts that were known on July 22nd.
No, but I'm trying to find a limiting principle here for the fact that we have an adoption where someone has full legal rights and constitutional rights to parent and has chosen who they want to be a guardian, especially in a case like this where she apparently knew that she was ill and that could lead to her death, and she's making provisions for her child. Would the tribe in that case, given the facts of this case, be able to insert itself into that case about who the guardian was for an enrolled member?
Your Honor, potentially, if they felt that guardian was unsafe or that child was in danger, potentially. But in July of 2023, no party was aware of the will. That will was not before the court. And it was not probated until about 9 months later. So I think under the facts of this particular case, that information wasn't known. What was known was that there was a petition filed by non-relatives. What was known was that this child was passed around from members of the church. And what was known was that there was no temporary custody in order in place for this child, and that she was removed from the jurisdiction without permission.
Go ahead, finish.
Now, I know the appellants have said that, the grandmother in this case gave permission for her to leave the state, but there's absolutely nothing in the record to show that. The site that was provided in their briefs is not accurate. So there's nothing to show that there was any permission for her to leave the state.
So your position is that adoptive mother's rights were terminated on her death?
Yes.
And that this was that this scenario fits under the foster care placement under Section 1903, correct? But how can that be where the definition states that 1903 applies where parental rights have not been terminated?
Your Honor, our first position is that the tribe had inherent sovereign authority to issue the ward order in this case, and that the state court should respect that inherent sovereign authority and uphold the dismissal. We also believe that if this court finds that the tribe did not have exclusive jurisdiction, because the only facts for exclusive jurisdiction are, is there an Indian child, and was there a valid ward order? And both of those facts are present here. And there's numerous case law, I'll point you to Holly v. TO Tribe, that say the court should respect tribal jurisdiction, should defer to tribal courts, should give full faith and credit, should give comity, and should not unnecessarily interfere in tribal courts. And so that is our first position. But secondly, if this court finds that there wasn't exclusive jurisdiction, there are other avenues for the tribe to have jurisdiction. One of them is concurrent jurisdiction under ICWA. And I think this was a child custody proceeding, whether you want to describe it as a foster care placement, a termination of parental rights, or a pre-adoptive placement. It was a child custody proceeding, and ICWA applies.
But there's no residual for other, such as in this case, under 1903.
There isn't a residual, but 1903 it doesn't exclude any other proceedings except divorce or delinquency. And so although there are the four categories, and those do have some meaning in other provisions of ICWA, there's the four categories. Child custody proceedings isn't limited to just those four categories. When ICWA wanted to exclude additional types of proceedings like divorce and delinquency, it's set forth in the statute.
Can I ask one follow-up? Just as and I asked Mr. Joseph this, but say that our decision is that there is concurrent jurisdiction. What is the last paragraph of our decision say? What should happen next if we say you don't have exclusive jurisdiction, you have some sort of concurrent jurisdiction, so the court got it wrong? What's the direction to the Superior Court from there?
Your Honor, if this court finds that there was concurrent jurisdiction, it is presumptive, meaning the court should transfer unless there's a reason not to. And we would ask this court to find that the Superior Court properly considered those findings at two separate hearings. And I will point out that the issue of transfer also came up at the July 20th hearing when the guardian ad litem was present and when the guardian ad litem waived his appearance. And the guardian ad litem has not filed a notice of appeal in this case. So we would ask that this court uphold the Superior Court's dismissal and find that he properly transferred under the concurrent jurisdiction provision.
Thank you.
Thank you.
Counsel, you have 35 seconds, but I'll let you go over a little bit over that.
I'll try to be respectful of this court's time. One thing I did want to point out factually, although the record is rather threadbare, with the record that the tribe filed, saying that this was just retaining jurisdiction from the original 2010 dependency, what it filed here has a different case number. So it doesn't appear from anything we can see from what it actually did file that this was an add-on case or that this was referencing a prior case. And the only other thing I would like to finish out on is that even if ICWA applies here, whether this is a pre-adoptive placement or a foster care placement, the court still committed 3 independently reversible errors in finding that it lacked any kind of jurisdiction, even concurrent, in failing to give the parties an opportunity to be heard at a meaningful time in a meaningful manner, and failing to hear out the child and make appropriate Rule 322 findings to transfer the case to the tribe. So for those reasons, I would ask this court to vacate the Superior Court's decision and remand for an evidentiary hearing. Thank you.
Thank you. Counsel, this matter is now under advisement. We will issue a written decision in due course. We appreciate your arguments and your briefing. Thank you. We're at recess.
Thank you.